the speakers take it from there. We'll have a question and answer session with the speakers, and then we'll after open it up to the public to also ask questions or give their contributions. Yeah, so that's how our session is going to go. So bail in itself is an agreement between the accused together with his or her sureties and the court, guaranteeing that the accused will pay a certain sum of money fixed by the court. And if the accused fails to show up or attend the trial on a specific date, the money is taken. The origin of bail follows the legal principle enshrined in Article 28 of the Constitution of the Republic of Uganda, which states that an accused is innocent until proven guilty. In addition to this, the laws provide that the right to bail is not automatic, but rather it's at the discretion of the court. Article 23(6) of the 1995 Constitution states that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court of law to be released on bail. And the court may grant the person bail on such conditions as the court considers reasonable. Yeah, so I saw Mr. Wanda already on, and I will ask him the first question. Council Wanda, according to you and your own simple terms, what is bail and what role does it play in Uganda's justice system?
Thank you so much, Rita. Good afternoon.
You will have to unmute your microphone because we can't hear you.
Can you hear me? Let me just a second. I think I'll just try to change the device. Can you now hear me?
Yes, we can hear you.
Can you hear me? Thank you so much, Rita. Good afternoon to all our guests who are on call today. Bail is a cognizance from Am I loud and clear? So I'm saying that bail is a cognizance from court where an accused person binds himself on their eventual appearance for the hearing of their matter. The role it plays into our justice system is we have a right to innocence. We are all presumed innocent until proven guilty. So the reason why liberty is granted until someone is found guilty is that they should not be condemned, neither should they be punished by being in custody when they are still innocent. So bail is it's just the cognizance which court gives to someone at the point when they have been charged, so that they can answer their charges when they are coming from outside of the cells. Over to you, Rita.
Thank you so much for that brief introduction and for your view. So my next question would be, because we have had the introduction that the person applies to court and then court grants bail upon its discretion. So my next question would be, what are these conditions under which bail is granted or denied in Uganda? Are they specific, or the judge just gets them off head or according to what he's feeling in the moment?
Thank you so much, Rita. So bail is governed majorly by one, the Constitution, then the Trial and Indictments Act, that's the TIA, and then the Magistrates Courts Act, which is the MCA. So these laws provide for the conditions under which bail can be granted. It's a discretion of court, but court must be very certain that someone will not jump bail and they will appear for their hearing. And when court using this discretion is expected to use the same judiciously. So what happens? What are the conditions that court looks at before granting bail? The MCA sets several conditions. One of them is the antecedents of the accused person. Previously, if there is any record of them having been granted bail, how did they take the same? Did they honor all the terms or they absconded? Then we also look at the gravity and severity of the offense in the event someone is found culpable. Court also looks at if the accused person has a fixed place of abode. Now, what is a fixed place of abode is that you must be coming from somewhere, you must be staying somewhere. What normally court asks for in such a scenario is letters of introduction from the local council area. Then also court looks at whether someone has sureties. Sureties are people who stand in for you to ensure that you will, they will make sure that you come and attend court. Now, these should be substantial. Court will look at so many factors in determining whether a surety is substantial or not. Therefore, court looks at all that combined, and then that they use that discretion to grant bail. However, if the case is triable by the High Court, then there's other conditions on top of what I've just mentioned. Among them is advanced age or someone being a minor, and the courts have gone on to interpret advanced age as someone who is above 50 years of age. Further to that is if there is no objection from the Director of Public Prosecutions, and or if someone's health is at risk and they cannot be treated from the place of custody. And this must be accompanied by a certificate from a medical personnel in the detention facility. So those are some of the factors that court looks at before granting or denying someone bail. Over to you, Rita.
Thank you so much, Wanda. So what does it mean for bail to be a constitutional right? What does this really mean according to you?
Bail is not a constitutional right per se. It is the right to apply for bail that is a constitutional right. Article 26, clause 6, paragraph A details that. So what makes the right to apply for bail constitutional is we go back to Article 28, where someone is presumed innocent until proven guilty, and then also the right to a fair hearing. So when we interlink these particular articles of the Constitution, that's when the right to apply for bail becomes constitutional. Because for as long as you're innocent, then you ought to enjoy your other rights under Chapter 4 of the Constitution. And also the right to a fair hearing. It involves you being in a position to prepare your defense. So it becomes really complicated for one to prepare their defense if they're in custody. So that's why court gives someone an opportunity to be on bail as they can prepare their defense the same way the prosecution will be preparing their case against that person.
Thank you. Thank you so much, Wanda. So you've talked about it being the constitutional right, and you refer to that article. We have seen certain things happen in the country. Certain honorables were granted bail when it came to the massacre case. Unfortunately, we saw them being whisked away at the same time after this bail was granted. So my question would then be, is there a sort of efficiency when it comes to this granting of bail, or is it just here? Is it just an article in the Constitution that is not really respected?
Thank you so much, Rita. What happened to the Honorable Segrinya and Honorable Alan Sewanyana? It's something which is not legally right unless there were other charges against them. You being released on bail does not bar you from being rearrested legally, for as long as the state has another charge against you. We first saw this, I think, in 2005, when we had the Black Mambas arresting the PRA suspects. We've seen it resurface over and over. We've seen it at the Anti-Corruption Court. Actually, the High Court, the Division of Anti-Terrorism. My colleague Geoffrey, who is always practicing in that division, will elaborate more on that. However, what happened to the two honorary members of parliament can be justified in some cases if the state had other charges against them. But if the state has no other charges against them, then they should never have been arrested in the first place.
Thank you so much. Mr. Geoffrey has joined us and we're elated to have him right now. So Mr. Geoffrey, I will direct the same question to you that I've just asked Mr. Wanda Ronald. And the question is, what is the efficiency of the law of bail in Uganda? And I gave an example of the honorables that were whisked away after they were granted bail. Is it just hearsay, or does it really work? Is there an efficiency to it, according to you? You're still muted, sir. Thank you.
Geoffrey, my apologies. I'm just from court, and I'm glad to be part of this. To go direct in answering that same question, one, I am sure the law is effective. However, the law being effective, it has its own loopholes. Though the loopholes are only being set up by different stakeholders. For example, in the judiciary, to the lawyers themselves, but mainly also politicizing the application for bail. Basically, that's it. We have several examples where even court itself grant bail, and then our clients are rearrested. We have scenarios where instances where bail is supposed to be granted, and judges in their rulings, they make everything political. Of recent, I had one concerning a Katumba suspect, and it's unfortunate that even the reasoning for failure to grant the bail was not or is not anywhere provided for under the law. However, the judge himself was protecting himself from any other eventuality. I think the challenge we have now is not the law on bail. It is on the administration and the way it is supposed to be administered or it is supposed to be applied. Simple as that.
Thank you so much, Mr. Geoffrey. So my next question will still go to you. And it is bail available for capital offenses, or they only grant it in cases that are misdemeanors and the like?
You know, bail according to the Constitution is for every offender or suspect or accused person, be it capital offender or not capital offender. The difference is in the application. Where in the small offenses you go orally, in the big offenses or capital offenses you file an application, which application the other side is supposed to respond on the same, so that the court gives a written ruling. Basically, that's it.
Thank you. Thank you so much. That has thrown a lot of light on the issue of bail. So, Mr. Wanders, according to you, is the availability of bail for capital offenses provocative and found to be interfering with security investigations?
Thank you so much, Rita. One, I don't believe that granting someone bail will interfere with investigations by the security. In advanced worlds, people are arrested after investigations are concluded. And ideally, if our security forces were acting in that manner, there would be no need for bail in most cases. Because if as long as someone is arrested, there is a speedy trial, then there's no need for bail. The challenge we have here is that people are arrested, then we want to conduct investigations. I think it must have been Olaro Tuno who took the government to court, where they arrest someone. After arresting you, they want to interrogate you to extract evidence from you. In other words, they want you to incriminate yourself. That should not be the case, ideally. So I do not think that granting of bail to capital offenders interferes with the investigations of the security. It's just that the security is never ready in the first place to prosecute these people. We've had offenses where someone has been out on bail, maybe let's say for 3-4 years, and at the end of the day, the DPP can no longer prosecute the case, and they withdraw it. Of recent, we came to learn of the withdrawal of the case against retired Colonel Dr. Kizza Besigye. They withdrew it in 2019. They had never informed him, but he had been arrested in 2016 for terrorism. So to me, the problem is not the interference. The challenge is that the arrests are made before the investigations are done.
Thank you so much, Mr. Wanda. So I would like to take this in a different angle. Most times bail is granted and we find the families of the loved ones in cases of, let's say, murder are grieving and they're not happy with the verdict. I can give an example of the Matthew and Desire case. Matthew was claimed to have confessed to the murder, but he was later on released on bail and he has gone ahead to secure his future. He has done his medicine degree. He is now a doctor practicing in Mulago. Don't you feel or don't you think that in such instances, this is provocative to the families that have lost a loved one?
I think Geoffrey wants to answer that, but I'll go first.
You have to unmute Geoffrey. We can't hear you.
So sorry. No, I was saying I wanted to take it on that question simply because I've been following up on Matthew's matter. What is important is to explain to the families of the victims the essence of the law, because the law is very clear, presumption of innocence. This person is still innocent until proven guilty. In fact, until the day of the judgment. Now, what is vital as the advocates are supposed to do, or any other person in authority, is to explain to them that this is how the law flows. This person is still innocent until the judgment is granted. What I think is vital is the preparation for the hearing, to tell the victim's family, let's be effective in the preparation so that we can put the accused person on spot. Simple as that.
Yeah, because now I'm seeing instances where people are released and then they're taken to the court of social media, the court of Twitter, or whatever courts of law that people have come up with because they feel like the law isn't doing them justice. My next question is the bail money that is given in or handed in by these people, and they're sure it is refundable, and how can they get it? What procedure can they use to access this money when the person is proven guilty, proven innocent, sorry. Mr. Wandasa.
Okay, I'll take that one. One, bail money is refundable only in one instance where the case has been concluded, finality. So either whether the person has been convicted or whether they have been acquitted, that money is refundable. The money is always paid to the judiciary account. So the moment someone is acquitted or convicted, then he's supposed to present the original receipt that you get after paying the money to the cashier, which is normally at the High Court the main High Court at State Square, and then you get your bail money back. So in most cases, it's refundable, only that at times people do not follow up, or maybe the procedures to getting it may be long, where someone may wait for some time and then they just abandon it. But it's meant to be refundable because it's just as a security for you to appear in court as and when required.
Thank you so much. So my next question would be, my follow-up question would be, is there a solution for me as to when I lose my original receipt? Then how do I go about that?
That may be looked at case-by-case scenario. In most cases, these documents are carbonated. The receipts are carbonated. So if you can recall the date when you paid your bail money, then ideally the cash office should be in position to retrieve the other copies of that receipt book, and then an exception can be created for you to get back your money without the original. Because even the law provides that where there is no original, then a duplicate can be used, but only in special circumstances.
Oh, thank you so much. That was very enlightening. My next question is, what happens, this goes to Mr. Geoffrey, what happens when bail is not granted? Can I appeal to the same court or to another court? How do I go about such circumstances?
One, if bail is not granted, one cannot appeal. Why? Because bail is just an intellectual application. What mainly we do is we go in twos. One, I can advise the client
Hello, Mr. Geoffrey, are you still there? I will have Mr. Wanda Samuel step in. Seems like the network is.
Most likely Geoffrey's network is disturbed because he's on the road from court. So what he was explaining is that you cannot appeal against a bail application ruling which has been denied. Reasons being is an interlocutor application. So what happens is we go back to the ruling, we find out the reasons why it has been denied. If it was an issue with your sureties who have been declared not substantial enough before the court, then you have to look for other sureties. And then you can reapply again. So the only available option there is to reapply in the same court for another shot on the application. If the issue is maybe you are dissident, then you would have to prove that my antecedents have been good previously. Maybe you did not mention that in your affidavit because the evidence in a bail application is by affidavit evidence. So if you missed out earlier in the first application, then you would have to patch up all the loopholes in your subsequent affidavit to ensure that you're granted bail.
Thank you. I will ask you to explain maybe what an affidavit is for the people who are not lawyers that are listening in, so that maybe they can catch up with us.
An affidavit is a sworn testimony, which is written down. Ideally, all applications have to be supported by an affidavit. So an application for bail is drafted, an affidavit is also drafted. The person who is in custody, that is the accused person, is taken to most cases, if they're in prison, the officer in charge of the prisons is the one who commissions such affidavits, because all of them are supposed to be commissioned. That's what we mean by oath. And then when it's commissioned, it's filed in court. So one of them is just the sworn testimony of someone.
Thank you so much, Mr. Wanda Samuel. I have two questions that I am left with. And then after, we're going to open this up to the public to give us their views and their questions. If you have questions for Mr. Wanda Samuel, and hopefully Mr. Geoffrey Tulemsima will also be back by then. Yeah, so my first question would then be, what reforms would you suggest to be applied to the law governing bail?
Mine may not necessarily be a reform to the law governing bail. Mine may be a reform in the entire criminal justice system. As I indicated earlier, if and at all times the state is ready to prosecute their matters, then bail may not be necessary in most cases. Because if someone is arrested today, they are arraigned in court tomorrow, the state is ready to proceed, maybe the defense can be given 2 or so weeks to prepare, to look through the witness statement, the statements of the accused and all the state witnesses, then therefore the matter can proceed. So to me, the law on bail is okay. Right now, it doesn't need any reform. We just need to change our criminal justice system, right away from the police at time of arresting, the investigations, the unnecessary adjournments from the state as they indicate they are still concluding on investigations, and then the human resource in the judiciary. If at all, at times, all judges and magistrates are available for these matters, all matters should be heard expeditiously. Thank you.
Thank you so much, Mr. Wanda Samuel. I'll ask Mr. Geoffrey about any reforms. What reforms would you like to see regarding bail or the system at large?
Thank you so much. I think I won't be different from my brother. I think there is no major reforms we need, especially in regards to the reapplication of bail. I think what is very vital is to handle the issue of administration in the criminal system, but mainly also to pave away the rigidity of most judges. Currently in Uganda, we have an issue that most of our judges have never been in practice. Now, they do not know what happens here. Secondly, most of the judges, especially in criminal litigation, they've never gone to prisons. You know, when you reach prisons, that's when you realize that bail is so relevant. Thirdly, our criminal system in Uganda, the moment someone is committed, it will take another 5-6 years for him to be cause-listed. And you know, that is entirely on the system, that's entirely on the judiciary. I think what I can call for now is to see better reforms in the systems, and then thereafter, we see how bail either is or proceeds effectively or not, because it is relevant.
Thank you so much, Mr. Geoffrey Tulemsima. And my last question before I open it up to the public would be, what is your take of the ODPP on the current debate of amending the law concerning bail? This is kind of related to the one I just asked, but I would love to know, what is your take, Mr. Wanda and Mr. Geoffrey Tulemsima?
Thank you so much, Rita. The office of the DPP ideally is they have no choice to them. You see, it's one the head of the institution is appointed by the head of state, who is a politician, and she's right now the current DP is, or even the previous ones have been there to implement the directives of the executive. So ideally to them, they may not look at it from the legal angle. They may not look at it from the justifiable angle. They will look at it on how to appease the head of state. And that's why you will find they may tell you that, yes, it's okay not to grant bail to the accused person because it's provocative. But ideally, that's not the truth. So to me, the office of the DPP is not really interested in even in handling the matters themselves, because we've seen people who have been charged and they have never been, someone is arrested, the file is taken to the DPP, it is sanctioned, and after 4 years, someone has never gone on trial. So to me, the root cause actually starts from the office of the DPP, because they should never even sanction some of these files, which would be leading to people being charged and applying for bail in the first place.
Thank you so much, Mr. Wanda Samuel.
Also, my take is very simple. Currently, we have a challenge that the government, especially through Parliament, want to amend the article in regards to the application of bail. Surprisingly, they have not consulted neither the Uganda Law Society, neither the DPP. Now, that alone is a challenge. We have currently a scenario of where most of the parliamentarians stopped at senior 6. Most of them are not even advocates. Now, that alone is a challenge. The best they only do will be to raise their hands to accept or not to accept. Now, my view is very simple, that before they come into that amendment, can they first consult, especially the major stakeholders? 1, the judiciary, 2, the legal fraternity, and mainly also the DPP. Currently, the DPP is silent, it's only waiting for one thing, the government to pass orders or to pass those amendments, and then they proceed, which is very, very ineffective, especially in a democratic society like Uganda. Thank you.
Thank you so much, our speakers, for answering our questions to the dot and spending time with us to educate us as we learn and unlearn certain aspects around bail. So right now, I'm going to open the floor up to the public to ask questions, to give comments. You can raise your hand and I pass you the microphone, or you can just type the question in the chat section of it. Yeah, so I will go ahead and check my chat. Okay, so far there is no question and there are no hands raised. Okay, I'm going to pass this around for the second time before I end the webinar and ask our panelists to give their closing remarks on the topic. Yeah, so if there are no questions or comments, I will ask Mr. Wanda Samuel Ronald to give his closing remarks on the topic, and Mr. Geoffrey Tuliam Sima to also give his closing remarks before I end the webinar. Oh, Mr. Tumwine Willis has something he wanted to say, so please unmute him. Again, let's unmute Mr. Tumwine Willis because he has something to say. As I wait for Mr. Tumwine Willis to be unmuted by our administrator of the webinar, I will go to the chats. Miss Florence Kabagumia says, thank you for the bail insights, Mr. Wanda and Geoffrey. That's from, and then I'm going to see if, okay, he says can't unmute, it's okay, thanks. Mr. Tumwine Willis says he can't unmute, it's okay, and thanks. Oh, we have missed out on your view, and we are so sad, but we'll have another webinar next month, and we'll be waiting for you. Mr. Wanda Ronald, please, and Mr. Geoffrey Tuliamsima.
Thank you so much, Rita, for moderating this session. I would be very happy to have gotten the question from my colleague, Tumwine. However, my closing remarks when it comes to bail and the current debate on it, more so from the executive, I think there is no need to rush to amend the law concerning bail. The executive should be very certain that the laws should not be made to fit a particular situation. Our laws should only be made for the greater good and cause for this country. We should make laws which should be better for the future generation. I remember one day when the Public Order and Management Act was being debated in Parliament. Several people warned our then Right Honorable Prime Minister Mama Mbabazi, because he was the one advocating for it. He did not know that one day he will be going to do consultations and then the police will stop him on the way. Indeed, it was passed. However, in 2011, when he was going to Jinja for his consultations, he was stopped and bundled behind the seats of double cabin police and was brought back to Kampala. So the laws should not be made to target particular sections of the public. Let them not be political. Let them be for the greater good and cause of this country. Then, as a whole, we shall have a better judicial, we shall have a better criminal justice. I see a question from Tumwine.
Excuse me.
Excuse me. I mean, I'm reading.
I see you. Does it erode confidence of the public to get to know that some of our judges have not literally practiced in Uganda, nor have visited prisons, etc.? What's the exact yardstick of appointing our judges? Geoffrey, do you want to take on this question?
Yeah, I don't have any, just what is the question? Just repeat it.
Our land colleague Tumwine Wills does it not erode confidence of the public to get to know that some of our judges have not literally practiced in Uganda, nor have visited prisons? What is the exact yardstick of appointing our judges?
Of course, the yardstick is very simple. One, you must be an advocate, and an advocate of more than 10 years in practice. Simple as that. Though that is more in writing. When you go back into the practicability of the same, it's totally different. This time around, you have to be a cadre. This time around, you know, the president in Uganda, according to the constitution, has full authority over all the three arms of government. Now, you are either his or not his. If you're not his, then there are consequences. If you are his, then you flow. I think it goes back now to you who have been appointed in that position. Yes, you may not have practiced for some good period of time, or you may have not gone to prison, but there are certain things which even the law, or you do not need any other person to do. You go to prison as the judge to confirm what's happening that side. Of recent, or some few months ago, I had a court of appeal session in Jinja, and all the three justices who appeared during that same week, we went and saw, or we went to Jinja main prison, and there were thousands of things we saw which could only be handled by a judge going to that side. I think it goes back to an individual which is far over and above the mere appointment.
Thank you so much. So I have another question in the chat. Why does government wait for someone to be given bail so that they prefer other charges? This is from Mr. Erisa. I'll have Mr. Wanda answer the question.
Thank you, Rita. I think Elisa's questions comes from the recent arrests of the members of parliament. So the question is that the government waits for them to get bail so that they can prefer other charges. the government just waits. It's just wanton. They look at someone should, it's disregard of the independence of the judiciary. So they look at it when someone applies for bail is granted, then they will just have, actually to me, that's not preferring other charges. To me, it's abducting. When you look at the manner in which Honorable Segninja was arrested, Honorable Swanyan was arrested, to me, that is abducting of citizens. I believe the government would have called the two members of parliament, the way they had been summoned in Masaka area, through the Speaker of Parliament, and would have appeared if there were other fresh charges against them. But the business of waiting for them as they are coming out of the prison cells, to just ban them into a drone waiting, to me that should not be something we should be discussing. Ideally, I condemn it in the strongest terms possible. No government should be abducting its own citizens in such a manner.
Thank you so much, Mr. Wanders. Mr. Samuel, thank you so much for your response. So I'm going to close up this webinar after we hear from Mr. Geoffrey Chiamsime and his closing remarks. And yeah, we'll take it from there. Over to you, Mr. Geoffrey.
Well, thank you very much. And I'm grateful for this webinar. And for every person who has been following, may God bless you or participating, and for the organizers. My closing remarks are in two ways. One, I think government should stop politicizing everything in the Constitution. If you look at the law on bail, it is very clear. It doesn't need to be taken somewhere, it doesn't need to be amended. In fact, amending it means that you are infringing on someone's right. But at the same time, you are showing that even the judiciary doesn't have authority, because the application for bail or the grant of bail is at the discretion of court. Now, if you come up and amend and you come up with your conditions, which you think they may be relevant as per your wish or your will, that is a sign that you have disrespected the article in regards to the independence of the judiciary. But primarily, I think someone has to be clear on the articles in the Constitution which cannot be amended per se or on the face of it. For example, if you are to amend the article in regards to the application of bail, that article goes hand in hand with the presumption of innocence. Now, if you come up and amend it, that means it is going to affect the one for presumption of innocence, which is an element of democracy, especially in Uganda. In conclusion, I think what is relevant is the sorting out of all the administrative issues we have, be it in or with the advocates or with the DPP or at police level or even with the judiciary. Simple as that. Thank you very much otherwise, and God bless you.
Thank you so much, Mr. Geoffrey Chiamsime, and thank you, Mr. Wanda Samuel. We are grateful for for letting us host you on this webinar. My name is Awuma Rita. I'm a junior associate with Simbel Advocates. And if you have any questions concerning the law, you can reach out to us on law@simbeladvocates.com, or you can call us on 0776 739 643. Please follow us on all our social media handles. We're on Twitter, we're on Facebook, and we're on Instagram as Simbel Advocates. From us to you, we hope you have an amazing weekend. Thank you for joining us again.